Committee of Advertising Practice. We're going to start the webinar in just over a minute or so. We're just waiting for a few more attendees. We've got a couple of hundred currently on the line, and we expect a couple of hundred more. So just one more minute, and then we'll get going on the webinar. Thank you. Okay, hello. My name is Ed Senior, for those of you who just joined. We're here at the Committee of Advertising Practice and the Advertising Standards Authority, and we're going to do a webinar on gambling ads that have particular appeal to children. We also have my colleague Sam Wilson, who is a compliance executive and gambling specialist, and we have Guy Parker, who is the Chief Executive of the Advertising Standards Authority. Now, you should have had time to read and digest the letter to which you received via the Gambling Commission on behalf of us and the Remote Gambling Association and the Gambling Commission. This webinar is to explain why you received that letter, what action you may need to take. And we will also go over a few case examples and explain why the ASA concluded that the specific ads in question have particular appeal to children or young persons. Do feel free to write in questions. We will try and answer a few of them towards the end of the webinar. We've had quite a few already that's come in, so that's great. But if we don't get around to answering your questions, then we will still look to respond to you, hopefully by the start of next week. We'll make those available. Otherwise, you can contact the CAP Copy Advice team, who are always happy to help as well. But first up, we have Guy Parker, the Chief Executive of the Advertising Standards Authority. Guy, do you want to talk a little bit about why we felt this letter was necessary, what the letter means for operators, and what action should be taken?
Yes, thank you very much, Ed. As Ed said, I'm Guy Parker. I'm the Chief Executive of the Advertising Standards Authority. Thank you very much for joining the webinar. There are nearly 300 of you on the call at the moment. Look, as we all know, there is currently enormous political and societal pressure on gambling operators to be socially responsible. There's public concern over whether we, as a society, have got the balance of gambling regulation right. There's a huge amount of media interest, and the government's report on gambling is imminent. It's never been more important for operators to demonstrate that they're playing by the existing rules, and that, of course, includes rules relating to gambling advertising. To be clear, gambling advertising includes operators' own advertising on their own websites, including game tiles. The Gambling Commission's LCCP stipulates at page 68 that operators should comply with the CAP and BCAP codes, and we will take action if operators choose not to. The codes require gambling to be promoted in a responsible way and place a particular emphasis on protecting children, by which I mean those who are 15 or under, and young people, by which I mean 16 and 17-year-olds. The rules prohibit betting and gaming ads being of particular appeal to children or young people, especially by reflecting or being associated with youth culture. Our clear view is that freely accessible gambling advertising on operators' websites, including game tiles, should not appeal particularly to under 18s. It is no defense to claim that it also appeals to adults. If an under 18 can view the advertising pre-verification, it is the operator's responsibility to ensure the ad does not have particular appeal to under 18s. And I want to stress that this is our clear view, and it is not a new position. The particular appeal restriction on content has been set out in the code since 2007. The joint letter we sent last Friday flags up our serious concern about website advertising, including game tiles, that clearly has particular appeal to under 18s. Operators need to review their website advertising and immediately amend or remove every piece of pre-verification advertising that might appeal particularly to under 18s. Anything that has a style reminiscent of children's characters or culture is going to be a problem in freely accessible space. And I'll finish by saying, if you're in any doubt, I urge you to check with the CAP copy advice team. Thank you, Ed.
Thanks for that, Guy. That's really good. Okay, so next what we're going to do is we're going to just talk through a couple of case examples, and Sam Wilson, who is a compliance executive and gambling specialist here, is going to talk through some of those. The first sort of question that we're going to put to you, Sam, is what do we mean by particular appeal?
So firstly, I should explain that for the purposes of the gambling rules in the CAP code, children are defined as people under the age of 16. Young persons, as Guy said, are people aged 16 or 17. One way in which the code seeks to protect children and young people is through highlighting that betting and gaming ads should not appeal to them in particular, especially by reflecting or being associated with youth culture. An ASA ruling in 2015 established that whether an ad had particular appeal to children depends on the test of whether its content appeals more strongly to under 18s than to over 18s. We'll look at that ruling in a few minutes, but looking at the example on the screen here, the issue is the graphics, including the cartoon dog in the larger image. The similarities with children's cartoons meant that it was likely the ASA Council considered to have particular appeal to under 18s. The council, when ruling on a complaint about this material, considered that the dog character was not adult in nature, and given that animated characters were very common in children's programming, the characters are likely to appeal particularly to children, especially in the context of the claim that Spin will whisk you away to his magical world through levels to collect extra bonuses. They also considered that names of games such as Jack and the Beanstalk, like on the right-hand side of the screen here, would be familiar to children. The games were presented with cartoon-like imagery, which was likely to strengthen that appeal. So the childlike personality here is clear and should be avoided. Leading on again, looking back to the names on the right, these were deemed to have particular appeal to children because of the combination of the graphics and the names of the games. Jack and the Beanstalk, as we said, being a particularly obvious example of something that is likely to have particular appeal to children.
Okay, well, so do operators need to reassess all material on their websites, on social media platforms, on third-party platforms as well?
We'd expect them to look at everything which is freely accessible. We'll go into freely accessible and what we mean by that in over the course of a few slides here. But basically that's where children can see it without registration or verification of their age. Anything that has particular appeal shouldn't appear in freely accessible space.
Okay, so in freely accessible space, do operators need to take action on material that has cartoons, graphics, images, especially of a childlike nature?
Well, they need to look at all advertising, and advertising here means, as is stipulated in the CAP code, anything that's directly connected with the supply of goods or services. So that includes anything in the context of gambling websites, promoting games and other services on an operator's website. They need to ensure that nothing is likely to have particular appeal to children and that it doesn't appear in space where they can see it. In the example we've got on the screen here, the ASA ruled after an investigation was undertaken into this advertising that many of the graphics and the names here were likely to have particular appeal to children. For example, Fluffy Favourites, Piggy Payout. However, something like the advertising for the Pharaoh's Lost Fortune game here is probably less likely to be problematic, as there's less of a clear, obvious link to children or youth culture. The line is obviously a difficult one to draw, and we do appreciate that. And as Guy said earlier, the CAP copy advice team is happy to provide advice and guidance on these particular issues relating to this. But operators do need to take action now to remove problematic content.
Okay, so is all an operator needs to do is remove a thumbnail for these games, the sort of game window on sites?
No, they need to remove anything in advertising. So that's on their website, on social media, and in third-party advertising like pay-per-click, search engine advertising that is likely to have particular appeal to children or young persons.
Okay, so are operators allowed to use animations, cartoons, advertising if they're more of an adult nature and not childlike in approach or style?
Well, I'm just going to show this example from 2015. So this is another one that the ASA investigated, and the complaint was upheld. Here, the graphics advertising this game were deemed to have particular appeal to children, and that was in conjunction with the text used. The ASA Council considered that the presentation of the pirate, the goat, which is the creature that we thought was a dog on the right-hand side, and the gameplay were colourful and exaggerated in style, and were not so differently presented as these distinct from a style of children's characters in cartoons or children's programming. They noted that animated animals and pirate characters were relatively common within children's programming and popular culture, and that therefore they considered the characters were likely to appeal particularly to under 18s. In this case, the advertiser argued that some of the phrasing included innuendo, like, I apologise for this, "you need that style to grab that booty," and that this showed it was targeted towards an adult audience. However, the ASA considered that the style of phrasing and wording, like "find you fortune," would further identify the character as a pirate to children and increase the appeal, and that the innuendo would not diminish this.
Right, okay. So operators should assess the whole content of an ad when assessing whether or not it's likely to have particular appeal to children.
Yes, that's correct. Wherever that advertising appears in freely accessible space and could be seen by children.
Great. So can operators, in any case, or any examples where they've used animation, characters in advertising that would be acceptable?
Yes, they can. They just can't use animation, cartoons, or animal characters that have particular appeal to children. There might be characters who have equal appeal to both adults and children, but if children are likely to be attracted particularly to a character or graphics used, this shouldn't appear, as we said, in space where they could see it. So, like I said, this isn't a blanket ban on using any animated or cartoon characters. For example, a complaint about this ad that's on the screen now for Foxy Bingo, it's actually a TV ad, but the principle applies to advertising and other media too, was not upheld by the ASA Council after an investigation into whether the Fox character was likely to be of particular appeal to children. Council, when they ruled on this, considered the style of ad, the character and scenarios shown were all likely to have widespread appeal, but that there wasn't anything in the design and presentation of the character particularly which was likely to have particular appeal to children. Again, context should always be considered, but this and the previous slide showing examples like the Pharaoh's Lost Fortune game demonstrate that operators do not have to completely avoid any animated characters, talking animals, cartoons or similar. In this webinar, we're just talking about material that is freely accessible. It can be accessed by children and those aged under 18, of course.
Right. Okay. So you mentioned freely accessible. Is it possible to go back to what we mean by freely accessible?
So freely accessible in this context means material that can be seen by anyone going onto a site either without registering or just by clicking maybe something like a simple box to confirm they're over 18. So something that can be done easily without, by anyone regardless of their age. CAP's advice would always be, as best practice, this material should appear behind a suitable age verification wall, probably something like a credit card check. But again, this is CAP's best practice advice, and it's for an operator to prove this area. Material only available beyond this point wouldn't be subject to what we're talking about here, because it would be clear that children were unlikely to see it. The website and this example on screen now, the advertising was deemed to breach the code in 2013, and when the ASA Council ruled on it, because it was, again, of particular appeal to children. It was necessary to register and confirm that a user was over 18 in order to play the game itself, but the advertising was available on the homepage of this company's website and could therefore be seen by anyone. The character of Spider-Man was deemed to have particular appeal to children, and the ad therefore breached the code. So the ASA Council noted the ad appeared on the website, which was accessible to visitors regardless of whether they were members or had registered. The CAP code states that marketing communications for gambling products should not be likely to be of particular appeal to children or young persons, especially by reflecting or being associated with youth culture. And while the ASA, in ruling on this ad, acknowledged that Spider-Man appealed to some adults, they considered that the depiction of the popular comic book character like this was likely to have particular appeal to children.
Okay, so taking all this into consideration, what should operators do now?
Well, first of all, they should review all of their marketing content. The main thing to do is to immediately remove, amend, or place behind a verification check every ad, every piece of advertising that they consider might hold particular appeal to children. Advertising here, as we said earlier, is anything that promotes the product. So it's likely to include everything on an operator's homepage. It's obviously particularly important to consider animations, characters, and product names in that context of whether they're likely to appeal to children. As Guy said earlier, this is a sensitive area. We do advise exercising caution. And again, the copy advice team are always on hand to help with any specific queries.
That is brilliant. Thanks, Sam. As up on the screen at the moment, CAP also has numerous other ways of providing guidance. You can follow the ASA and CAP on Twitter. They provide inside articles and updates via email on the website. And there's events and bespoke seminars as well, which operators can take advantage of as well. There's also the free copy advice service, which I'm more than happy to help with any queries you have on individual specific aspects of ads. As well as obviously the advice online articles and weekly rulings that appear on our website. There's also an e-learning responsible advertising and gambling advertising module that has become available on our website. So that also aids you in helping to stay compliant with our code. So take advantage of all those different sort of forms of advice, and we're more than happy to provide as much as possible in any format that we can. We just have time for a few questions that have come in. So, Sam, if you don't mind, we do the questions we've got. One of them is: do gambling businesses need to anticipate the case of negligent parents, for instance, by where they don't use parental control on their own computers or phones? Is that something that gambling businesses and operators need to anticipate?
Yes and no, I'm afraid is the answer. So it depends how we're looking at this question. If the reference is to parental controls here and having things like broadband safety walls and firewalls preventing children from accessing gambling sites at all times, then yes, operators do need to anticipate this, because obviously it's not going to be, not all children are going to be accessing via computers that have got this. And as we discussed, the onus is on operators to have a robust method for identifying the age of the visitor or the members of their site. However, if the question is more about whether parents staying logged into their own accounts on operators' websites and a child is then accessing that, then they're effectively accessing a part of the website that is appropriately age-gated, verified, and provided that method is sufficiently robust, we wouldn't, of course, expect operators to anticipate this or take action to mitigate the effects.
Brilliant. Okay. So moving away sort of slightly from operators' own website, one question here is the Apple Store a place considered as likely to appeal children if the game is only downloadable for those over the age of 18?
So to be clear, the rules, CAP code that the ASA administers applies, the rules apply to advertising. So the Apple Store and similar other platforms like that are just that. They're just the platforms, like the sort of the media space. Operators need to think about the content of the ad and the ad itself that is under their control. Gambling is obviously a product that is for those aged 18 or over. If an ad holds particular appeal to children on a website, is likely to be problematic if it's freely accessible. The same principle here applies to third-party platforms like the Apple Store. There's no method in place, or if there's no method in place prior to seeing the ad on something like the Apple Store, and that ad does hold particular appeal to children, it's likely to be problematic and breach the code.
All right, okay. We've also had a question just come in from an affiliate who advertises for sites and for gambling products for a gambling operator, and they're querying whose responsibility is it to make these changes? Is it the affiliate's responsibility, or is it the operators?
Effectively, in all cases, we would hold an affiliate and advertiser jointly responsible for the marketing published by the affiliate. This is a position the ASA has confirmed in various previous rulings where affiliate marketing has taken place, and it's reiterated in the CAP Advice Online article on affiliate marketing, which can be found on the ASA website by searching for affiliate marketing. However, in terms of who's responsible between an affiliate and an operator for making amendments, that's a discussion that operators and affiliates need to have between themselves, and CAP would always advise that that's good contracts are drawn up between these two parties to ensure that it's clear who holds responsibility. And as I say, if the ASA publishes a ruling on one of these ads, they're likely to name both the affiliate and the original advertiser and hold them jointly responsible. Okay, so one for those to discuss.
We've also had a few questions here about the definition of appealing to children, and to clarify what we mean when we talk about the use of particular colours or characters. Is there anything we can say to that?
Again, there is no absolute definition. Like I said earlier, we appreciate there are areas of subjectivity that are going to be difficult for operators to consider. But as I said earlier, it is the overall content of the ad that operators do need to think about. It's the execution of these elements that poses a risk, rather than necessarily the elements themselves. There isn't, for example, a list of things that are unacceptable, and it will always be a case-by-case judgment on the ad in question. Sometimes whether it's something that the CAP copy advice team can consider and whether the operator needs to consider themselves, or whether it is the ASA investigating. What you need to do, and what the ASA, CAP, Gambling Commission and the Remote Gambling Association are asking you to do here, is to think about the name, the images, the characters involved, and whether or not these individually or combined have the likelihood of appealing more strongly to children, particularly, like we said, by being based on youth culture or containing items that are associated with children and likely to be particularly appealing.
Right, okay, coming quick and fast now, Sam. Here's another one that someone's just said. Can we confirm what you mean by an ad, particularly in relation to websites?
So the CAP code said applies to advertising in a wide range of media, including on a company's own website, that's been the case since 2011, or in other non-paid for space online, which is under an advertiser's control, where the content is directly connected with the supply of goods, services, or probably less likely to be applicable here, opportunities or gifts. So this means that in addition to things like paid for ads in third-party space, online, and email marketing, images and text on a gambler's own website or their social media platforms that are, again, directly connected to their gambling products or services will be considered advertising for the purposes of the code, and be considered ads by the ASA. This is likely to include, for example, as Guy alluded to, the game thumbnails, screenshots, logos, anything that is likely to encourage a consumer to take a transactional decision there, really. So it can include names, descriptions of games.
Brilliant, thanks for clearing that one up. And on to the last question, I think we'll take it for time reasons, but someone has asked, can we rely on market research about the popularity of a particular game if that research shows that the audience is primarily adult in nature?
Well, in terms of evidence to support an argument that material doesn't appeal to children, the ASA would always take that into account if they're investigating a complaint about an ad, and they'll always consider this, but it will be dependent on how robust the data is. It's up to an operator, as all advertisers in all sectors, to ensure that they hold sufficient evidence to prove that their advertising doesn't breach the code if the ASA do undertake an investigation.
Brilliant, thanks for that, Sam. Thanks for answering those questions. For time reasons, we're going to end that here, but obviously you can still send in questions via the email address that we sent out with the invite to this webinar. It's samw@cap.org.uk. We'll be looking to respond to questions hopefully by early next week. We also will have a copy of the webinar which we can provide as well. But just to reiterate, you know, in terms of what to do now, it's review all your marketing content, immediately remove, amend, or place behind a verification check every ad that you consider may hold particular appeal to children. And advertising here is anything that promotes your product, for example, anything on your homepage, and you should be really cautious when using animation, characters, and product names. So we'd strongly advise to exercise caution, and obviously you can contact the copy advice team, who are more than happy to answer any further queries on individual ads as well. But thank you, Sam, for answering those questions and talking us through that. And thank you, everyone. We hope you found that helpful and useful. Goodbye.